Pranam Laksh.
Pranam. From the medical list under the heading for orders, item 1, criminal appeal DB number 315 of 2020. Mr. Nityanand Sahai for the appeal.
May I please, senior counsel argue in this case.
We are appearing in this matter, my lords. We have filed IA petition in this case. Earlier, his IA was not praised before he came over. The order is at Nectar 1, page 13. Does not praise the prayer for suspension of sentence of the appellant made through IA at this is. What is it not praised? It was not praised at that time.
What is the custody period?
My lord? Custody, my lord, he is 4th November 2018.
So 3 years and 4 months.
Yes, the point for my lord's kind consideration in this case is this. Conviction under section 376. The volume, देखो तो speaker में नहीं आ रहा. Conviction under section 376 DA and under section 5G of the Prevention of Children from Sexual Offences Act. Now, in my humble submission, I refer for lordship's kind consideration. Speaker लगाओ ना जी.
Yes.
My lords, the speaker देखो तो नहीं आ रहा आवाज. इसको हटा दीजिए. Now, in this case,
Yes. Yes, Mr. Roy.
yes, my lords, I am placing for lordship's kind consideration the evidence of PW6, the victim. My lords, paragraph 2 of her evidence, if lordship may kindly peruse for a moment. May I read it, my lords?
What do you what does he say?
My lords, what I am submitting for lordship's kind consideration, what she has said. Para 2 of her evidence, if lordship may kindly peruse for a moment, my lord.
Yes.
May I read her evidence, my lords?
Read it.
Yes, I will refer only 2 paragraphs, paragraph 2 and 16. First I am reading paragraph 2. यह घटना दिनांक 29/10/18 की है, समय 7 बजे सुबह की है. उस समय मैं अपने घर में स्कूल जा रही थी. रास्ते में झाड़ी के पास 2 लड़का छुपा हुआ था. लड़कों ने मुझे झाड़ी के पास ले गया. लड़कों के पास चाकू था. उन लड़कों ने जबरदस्ती मुंह दाब दिया, गर्दन पर चाकू रख दिया तथा मेरे साथ गलत काम किया. उन लड़कों ने मुझे धमकी भी दिया कि बात अगर आगे बढ़ाओगी तो तुम्हें जान मार देंगे. Now I am referring for lordship kind consideration paragraph 16 of her evidence.
Yes.
गलत काम का अर्थ है मुझे अभियुक्तों ने धक्कड़ पकड़ किया. घटना स्थल की चौथी निम्न प्रकार है. उत्तर सो. तो गलत काम जो पैराग्राफ 2 में कहती है उसका अर्थ क्या है? वो कहती है कि पकड़ धक्कड़ किया. That's all. In the entire evidence in my humble submission.
Yes.
I will refer for lordship kind consideration the sections now that have been corroborated by the doctor also. The doctor has not found any sign of it. Now, in my humble submission, my lords, I will refer for Lordship kind consideration. My lords, 5G, first I am reading section 5G of the Protection of Children from Sexual Offences Act. My lords, whoever commits gang penetrating sexual assault on a child, 5G, Lordship may kindly see, under which he has, the appellant has been convicted. Now, my lords, penetrating sexual assault has been defined under section 3 of the Prevention of Children of Sexual Offences Act. My lords may kindly peruse section 3. If my case comes under that, my lords, then definitely he does not deserve bail. But if I can satisfy this honorable court from her evidence that no rape was committed, then in my humble submission, Lordship may kindly peruse first section 3 of the Protection of Children from Sexual Offences Act. What is the meaning of penetrative sexual assault?
Yes.
Now, in my humble submission, I will refer for Lordship kind consideration section 7 of the Protection of Children from Sexual Offences Act. Now, allegation है कि पकड़ धक्का किया. Now, section 7 देखा जाए, what is the meaning of पकड़ धक्का? May I read my section 7? Sexual assault. Whoever with sexual intent touches the vagina, penis, anus or breast of the child, or makes the child touch the vagina, penis, anus or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration is said to commit sexual assault. And what is the punishment of sexual assault? Section 8 of the Protection of Children from Sexual Offences Act, my lords may kindly see what is the punishment. Section 8, my lords, I am reading for lords kind consideration. Punishment for sexual assault. From the evidence of the child, which I have just now read, my lords, punishment for whoever commits sexual assault shall be punished with imprisonment for either description for a term which shall not be less than 3 years, but which may extend to 5 years, and also liable to fine. So, in my humble submission, at best from the evidence of PW6, the victim,
Yes.
it will be a case of sexual assault. Otherwise, it will never be a case of penetrating sexual assault, which has been defined under section 3 of the Protection of Children from Sexual Offences Act.
Yes. Yes.
If Lordship may kindly peruse, what is the meaning of, in view of 5G, gang penetrative sexual assault? Now, penetrative sexual assault under section 3. Lordship got it, brothers?
Yes. Yes.
Kindly see, brothers. A person is said to commit penetrative sexual assault if A, B, C, D. If, brothers, that is committed as defined under section 3 of the Act, then definitely it will come, brothers, under section 5G of the Protection of Children from Sexual Offences Act. Now, in my humble submission, similarly, 376DA, under which he has been convicted. Now, if Lordship may kindly see section 376DA of the Indian Penal Code. Kindly see under section 376DA.
Yes.
Punishment for gang rape on women under 16 years of age.
Yes.
Where a woman under 16 years of age is raped by one or more person. Now I pause for a moment here. Now in my humble submission, age is raped. Raped is the word under section 376DA, and the rape has been defined under section 375 of the Indian Penal Code. What is the meaning of rape?
Yes. Yes.
I was in my humble submission, 375 of the Indian Penal Code, if Lordship may kindly see, and Lordship may kindly peruse the evidence of the victim PW6. If from her evidence, rape has been committed, in view of the definition of rape under section 375 of the Indian Penal Code, or under section 3 of my lords, Protection of Children from Sexual Offences Act, penetrative sexual assault, then definitely, my lords, in my humble submission, the offence is committed. Entire evidence, my lords, I can read of the victim, PW6. Nowhere she has said that rape was committed. Galat kaam kiya. Then she has clarified what is the meaning of galat kaam. Paragraph 16 of her evidence. Dhar pakad kiya. My lords, for that he cannot be prosecuted, punished under section 376 DA or under section 5G of the Protection of Children from Sexual Offences Act. Cannot be in my humble submission.
Yes, yes.
And my lords, the evidence of the victim, PW6, has been corroborated by the doctor also, PW11. My lords, in my humble submission, if Lordship may kindly peruse the evidence of the doctor PW11, I am replacing for Lordship kind consideration. One Roman 8, Lordship may kindly see. First, the evidence of Dr. PW11. Injury, no external injury of the body. Not corroborated with regard to the allegations made in the evidence that she was assaulted or this, that. Nothing. Then kindly see paragraph 11 of the PW11. The medical board was constituted and the medical board did not give any positive opinion regarding rape with the victim. What she has said in her evidence, PW6, that is corroborated by the doctor, medical board, PW11. And further, Lordship may kindly find, I am sorry, my lord, this point has not been taken by the appellant in this case, but my lord, in my humble submission, the appellant was juvenile at the relevant time, 18 years of age, at about 18 years of age. From the judgment, it will appear that point was not taken in my humble submission earlier, but that point in my humble submission can be raised at any stage in my humble submission in view of the and with regard to this, my lords, in the judgment, if Lordship may kindly see when the judgment was delivered, if Lordship may kindly see the judgment when it was delivered on 7th February 2020, at that time, my lord, the Learned Court Bureau has assessed the age of the victim 20 years. And the occurrence alleged to have been committed in my humble submission in 2017. Date of occurrence is, my lord, that is
30
eh?
29/10/2018.
29/10/2018. This point of juvenile has not been taken in my humble submission, so we will not take this point for the present matters in my humble submission. But the points which we are raising for Lordship kind consideration, that if from the evidence, number one, I am summing up my submission for Lordship kind consideration, if from the evidence of the victim PW6, entire evidence, if Lordship permit us to read, we will read the entire evidence, and there is whisper of committing of rape, then in my humble submission, and the doctor's evidence also, no rape was committed. Galat kaam kiya. My lord, galat kaam she herself has said in her evidence. Galat kaam का मतलब वो बताती है कि क्या होता है गलत काम. Para 16 I have already referred for Lordship kind consideration. Under these circumstances, we pray before this honorable court. Though first time when he had filed this petition, it was not pressed. We are pressing for Lordship kind consideration. I don't know what is prevailing in your Lordship's mind, taking into consideration the evidence of the victim and the provision of law, section 3 of the Prevention of Children from Sexual Offences Act, section 375 of the Indian Penal Code, Section 376 DA of the Indian Penal Code and 5G of the Prevention of Children from Protection of Children from Sexual Offences. This is my submission, for Lordship, kind consider.
Yes. Yes, Mrs. Bharti.
Lordship, medical report is against him, Your Lordship. There was fresh bleeding on the private part, Lordship. Is it just about 15 years? That has been assessed by the medical board.
Yes. Yes. Sister.
Lordship, whatever argument he is advancing, when the medical report was, when he was confronted with the medical report on the last occasion, after some argument, the learned senior counsel was only appearing on the last occasion.
So
So,
situation remains.
Lordship, therefore, the order may be passed on merit. Repeatedly, everything is marked in my second copy, whatever he has stated.
Yes. Heard learned senior counsel for the appellant.
May I pray one thing, my lords?
Yes.
May I pray one thing? I don't know what is prevailing in your Lord's mind. That
Yes.
is not inclined to grant bail.
They will be going soon.
Not inclined to grant bail. Then, my lords, only 3 years and some months he has remained behind the bar. And also, after completion of 5 years or 6 years, my lords.
So let us express our opinion now. Every time we have to recollect as to what.
No, my lords, in my humble submission, Lordship may say that what is your view? Lordship, in my humble submission, I have done my duty.
So
Yes,
we will also do our duty.
if I fail to satisfy this honorable court, then my lords, in my
Half an hour, Mr. Roy, we are hearing you. We wish to pass the order on merits.
no, that's true, my lord. But what
That's it.
I'm saying,
We have heard you very patiently.
all
Now
right,
you listen to the order very patiently.
we are very much obliged that Lordship heard us patiently, my lords. We are very much obliged.
So we will pass an order on this. You may renew it after some time.
All right, my lords, all right.
Heard learned senior counsel for the appellant, Mr. P.P.N. Roy, assisted by Mr. Krishnanand Sai and learned APP, Mrs. Vanna Bharti, on the renewed prayer for suspension of sentence made through IA number 1961 of 2022. Sole appellant stands convicted by the impugned judgment dated so-and-so, passed in so-and-so by the court of so-and-so for the offences punishable under section 376 DA, 506/34 of the IPC and section 5 within bracket small g/06 of the POCSO Act, read with section 03W within bracket small I of the SC/ST Prevention of Atrocities Act 1989 within bracket Amendment Act 2015, and has been sentenced in the following manner. Here page 45, running page 7. Stop. Earlier, the prayer for suspension of sentence made by this appellant was dismissed as not pressed by order dated 23rd September 2021 on IA number 4193 of 2021. Stop. Then senior counsel for the appellant has drawn the attention of this court to para 2 and 16 of the deposition of the victim PW6, which according to him clearly demonstrates that there has been no penetrative assault constituting rape in terms of section 3 of the POCSO Act or in terms of section 375 defining rape. Stop. Therefore, no case of gang rape under section 376 DA also could be made out. It is further submitted that mere grappling or touching of an organ of a child would at best constitute an offence punishable under section 8 of the POCSO Act, which is only up to 5 years, which is up to the maximum of 5 years. It is further submitted that the appellant, the medical officer PW11 who was part of the medical board, the doctor, PW11, who was part of the medical board, has not given any positive opinion of rape upon the victim. Stop. The appellant has remained in custody since 4th November 2018, that is about 3 years and 4 months. By now, as such, he may be enlarged on bail. But learned counsel for the learned APP has opposed the prayer. He submits that the opinion of the medical board is against the appellant, who is a minor, as also assessed through radiological examination by PW3 doctor, right, Exhibit 1. Stop. Report of the medical board is the report of the medical board is Exhibit 10/02 and Exhibit 11/1, adduced by the other doctor, PW12. Stop. Therefore, appellant may not be enlarged on bail. We have considered the submission of learned counsel for the parties and gone through the materials placed from the lower court records. On consideration of the materials on record, and particularly the opinion about age of the doctor, PW3 and 11, and also the finding of the medical board that the hymen was fresh torn with fresh bleeding present, which showed that possibility of rape could not be ruled out. We are not inclined to enlarge the appellant on bail by suspending his sentence at this stage. Accordingly, IA number so and so is dismissed.
Some liberty is given.
We always indicate at this stage, so thereafter it is up to the councils to advise when to move, when to not move.
All right.
For admission, item 2, contempt civil 742 of 2021, Mr. Prabhat Kumar Sinha for the petitioner, Mr. Raju Rani for the opposition.
Lord, pursuant to the last order, my lord.
Because we have filed a supplementary show cause minutes, bringing up regard to breakage of agreements minutes and also an application filed by the petitioner.
So, what is your explanation?
Lord, in the supplementary so-called, my lord, they have only given the breakup, how they have come to the conclusion, and one application submitted by the petitioner at the time when his matter was considered for compounding of the offence for opening the shop. These two letters have been enclosed.
And Extra A Mills at page 14 Mills is the letter Mills dated 19/1/2022 Mills. Mills here.
Mr. Piyush,
Mills.
you have imposed penalty upon him because he was found guilty.
Mills.
So how does that make a difference?
Mills, but we have not cancelled his license Mills in terms of.
Who bothers about it? You
Mills,
cancel. You could have cancelled immediately.
Mills,
The moment this letter was issued, when?
This letter was issued on 19th Mills and on
19th of which year?
19th of January 2022 Mills.
19th of January 22.
Annexure A. Top left side the date is mentioned.
This application was submitted by the petitioner on 19th of January 2021.
He has admitted his guilt, Mills, and
thereafter, my lord, they have imposed penalty and passed the order for the imposition of 1 lakh penalty.
So he has admitted his guilt, and then you have passed the order of penalty.
Mills, but we have allowed him to operate, Mills, after imposing a cost of rupees 1 lakh rupees Mills as penalty. Mills, we have not cancelled his license, Mills.
Why have you allowed him? He was found guilty.
Mills, he has requested Mills may just, if I may place the application, Mills, Milord's permits.
He has requested, so certainly you will take steps as per law, no? You cannot take
We
steps
have
as
taken
per
a lenient view, Milords, and we have allowed him to continue, Milords. He has accepted his guilt, Milords.
The point is whether for the intervening period you could have charged or not. That is the only point.
Milords, had he not made this application, Milords, in terms of Section 59, Milords, we would have gone ahead and cancelled his license from the day the shop was sealed, Milords. And from that day
would have
onwards,
been better for him. From the day the shop was sealed, if the license would have been cancelled, then he would not have been made to pay any amount thereafter.
but
do that.
consequently, Milords, he would not have been allowed to reopen the shop also, Milords.
He has not yet reopened. Has he reopened? Who
Yes,
is losing the revenue?
we have
Are
now
you running the shop?
we have given him the consent to reopen, Milords.
He's running the shop?
No, my lord, not. Only for some period, my lord. They have opened my shop on 29th of January, and on that same day they have made a demand. And since we have submitted an application, since the license was suspended during this period, this demand cannot be met. Thereafter, my lord, they have made my wallet negative. I cannot take any issue. Whatever there was in my shop that I was selling for few days, and immediately thereafter, my lord, they have cancelled my license. So this is the leniency that they have allowed me to operate my license for few days, and for that I have been charged 2.5 crores. And they are charging all this late fine, everything for the period they are, as per them, they are during this period my license was suspended.
Mr. Chitresh, your officer does not want to give any proportionate reduction in the excise duty and excise transport duty.
Because that is beyond their powers, Milords. That we have discussed, Milords, but that is beyond.
Our judgment is a waste paper.
No, Milords, that is because they have not imposed penalty, Milords, the late fee, Milords, for the period from 15/10/2020 to Milords, the date from which the fine was imposed.
Mr. Chitresh, please appreciate, if there was delay on your part, right, as held by this court, then why should this amount be not recovered from the concerned officer?
Milords, by imposing a penalty of rupees 1 lakh, Milords, we have not.
No.
We have not proceeded to Milords, prosecute the Milords, the licensee in.
You prosecute, you hang him. We don't bother about it. If the law permits, you hang him. We are not bothered about it.
As he had made this application before us,
you have already hanged
him and Milords not to prosecute him in a criminal case, Milords, in terms of Section 59.
So it's a mercy. Mercy beyond law. Mercy beyond law is itself cruelty. Mercy, you have shown mercy beyond law. Is it coming from your own house? It's state revenue. You have to act as per law. Who stops you from acting as per law? You have deprived him from operating on account of your own laches, and you want him to pay the excise duty and the transport duty. You fix the liability on the concerned officer. Realize it from him. That you will not do.
We will proceed against the officers.
Yes, Lord.
Milords, if I may only place the relevant part of the application, Milords, which was received by the petitioner, Milords.
No, your officer, once we will start our proceeding and then he will explain and we will see. Because at this stage, we are not satisfied. He will have his opportunity because once we start the proceeding, he will have his opportunity. He can engage an independent counsel also. Why should the state government represent a contender? Let him engage his own counsel and spend 2 crores of rupees.
Because the petitioner himself has he has stated मेरी
No,
प्रथम
no,
भूल को
no. You
मानते
see,
हुए
Mr.
आर्थिक दंड
Chitresh,
देकर
you see,
मतलब
as expressed by Lordship and as my concern also, we are not we are not accepting the show cause as of now. We will initiate a proceeding and then we will see what all explanation he has to give. It can still be dropped. There is no bar in law. But you will not represent the contemner. AG office will not represent the contemner, I suppose. The orders are to be implemented in letter and spirit. That is the law.
Mr. Chitresh, we are inclined to issue notice on the opposite party number 5 and 6. They are the concerned persons.
my lords.
So we are inclined to issue notice to them as to why contempt proceedings be not initiated against them. If you want to have a consultation for 2 minutes with the officers, you can do so, because otherwise the ball will be set in motion.
Milords, may I Milords request this case to be taken up tomorrow, Milords? I'll have a consultation with the officers, Milords.
This bench is a special bench, na? So we have to accommodate. So tomorrow or what? They know that this is a special bench and it is being adjourned for week or more because of this reason.
And Lordship, our concern should also be that petitioner is not operating. The state is losing its revenue.
All that we understand, sister. That is why we have passed a judgment. If they don't obey, then let them face them.
That's right.
Milords,
How many times do we need the explaining part?
We cannot write orders on their behalf.
And every day explaining as to what we have indicated in the order. All they understand. We have for the past 2-3 dates we have been explaining all how the court has read its order. Still they want to stick to their stand, then let them face contempt.
Milords, if I may pray, Milords, tomorrow, Milords, at 1:30, if it is fixed, Milords, we'll have a consultation, Milords. We'll call the officers, Milords.
No. Order to notice will be issued today. If they want to rectify the order in terms of our order, then you can have for tomorrow also or day after tomorrow also.
Milords, that is Milords. That is why, Milords. We will have a consultation, Milords, and we'll try and Milords rectify the order.
So, but no bargaining business in contempt.
My lords.
We have wasted enough of our time trying to convince and persuade that this is the import of the judgment, and they are throwing their hands up that this is not within their power. Then they will understand what is within our domain and how they are in contempt. These words are not used idly. On the last occasion itself, sister had read out the last 3 lines of the first paragraph of the judgment and then the operative part in the next paragraphs. When we have clearly said that, therefore, the delay in deposit of ED and ETD together with penalty for that period, the petitioner cannot be made liable alone. You are making him liable alone. So this is in breach of our order. You can have instruction, because if you take time and then they do not do, we will take a more serious view of the matter on the next.
Milords, they will Milords amend the order, Milords. I'm sure that's what court will do. I will do the meeting.
Opposite party number 2 has filed a show cause on 11th March 2022, which is not in consonance, which has given a breakup of the penalty imposed upon the petitioner. But
Actually, they are given the breakup of penalty, the license fee, as well as the transportation duty. All three.
the breakup of penalty, license fee, and
Excise duty and
Excise transport.
excise transport duty.
transport duty.
Yes, Lord.
Stop. However, though despite indulgence granted earlier, the reasoned order dated 3rd March 2022, bearing number 308, taken note of in the order dated 7th March 2022, have not been amended or rectified to bring it in consonance with the order under offence. Stop. Learned Counsel for the State, Mr. Piyush Chitresh, AC to AG, submits that the opposite party concerned may be granted one more indulgence to do so. In view of the fervent request made by Learned Counsel for the State to enable the concerned opposite parties to do so. Let the matter be listed on 25th March 2022. Show cause, if any, can be sent show cause, if any, containing the amended order can be filed through email also before the next stage. We are not even asking for their presence till date, but we will not wait for starting the proceedings, because we do not want the officers to spend their time in court proceedings. Let them do their work, but do it as per the dictates, the mandates of law and the court's order. So I forgot that we are not the regular bench. I thought we will call the next cases on the list. So,
I'll just quit, Lordship.
okay, sister. I'll join as soon as brother comes.
from the deposit under the heading for admission. Item number 14, WPT number 745 of 2021, along with item number 15 to 25, Mr. N.K. Prasadi for the petitioner.
The lead case is serial number 16, WPT 28 of 2021, Manoj. That is the lead case.
Okay.
My lord,
Yes.
on the last occasion, my lord,
Yes.
I was required to give a gist of the reasons or grounds why, to satisfy the court, why the authorities under 108 shall exercise the revisional jurisdiction and how the orders impugned are erroneous and prejudicial to the interest of revenue only for satisfaction of the court.
Yes.
In all the matters, I was directed to submit a gist of it, my lord. And accordingly, my lord, in compliance therefore, my lord, a gist has been submitted, setting out 8 points, showing how the conditions of 108 stand satisfied in our case, in each of the case, my lord.
Yes.
And my lord, subsequently, concise written notes of arguments along with propositions have been sent, my lord.
Yes.
And gist of case laws have been sent, my lord. Gist of case laws. One, my lord, written note is there with propositions.
Yes. Yes.
One, my lord, grounds for invoking jurisdiction under section 108. In
Yes.
all the cases, separate sheets have been given.
Yes.
And there is a gist of case laws, my lord.
Yes.
And there are 3 volumes of judgments, your lordship.
Yes. Right.
Judgments are in 3 volumes, my lord.
Yes.
So, my lord, to have a glimpse of the proposition, my lord, so that the arguments that I made on the last occasion, only to recapitulate that. In fact, my lord, almost I had concluded my argument, only to recapitulate that and to demonstrate that from this synopsis given in each case separately, that a case under 108 is made out. Only on these 2, my lord, I make submissions.
Yes.
And see my lord, propositions. A.
Yes.
The SSC registered person can invoke jurisdiction of revisionary authority under section 108 of the GST Act 2017 by way of furnishing information in the form of application that a decision or order impugned is erroneous insofar as it is prejudicial to the interest of revenue and is illegal or improper or has not taken into account certain material facts.
Yes.
Then, my lord, B. Once the conditions of erroneous and prejudicial to the interest of revenue and illegal or improper or has not taken into account certain material facts is satisfied, the revisional authority under 108 of the GST Act 2017 has to be excised. Discretion under section 108 is to excise judicially and reasonably. See, my lord, prejudicial to interest of revenue is not confined to loss of revenue, but prejudicial to revenue administration. Then D, my lord, in the instant case, entire procedure suffers from illegality, impropriety, and material irregularity and miscarriage of justice as the mandatory show cause notice under 74(1) of the GST Act 2017 read with Rule 142, 1A of the GST rules of 17 is never issued. Only summary in form DRC-01 issued. In the instant case, use input tax credit is denied along with interest and penalty on the basis of sample transactions without proper investigation inquiry into each transactions. This is the proposition, my lord. And my lord, I had argued, and it turned to my lord next page.
Yes.
And my lord, I had argued that the revisionary jurisdiction under section 108 can be exercised by the revisionary authority in either of three ways. Para A1, kindly see, my lord, on his own motion. I will take your lordship to the act just to have a glimpse of what I have argued, my lord.
Yes, yes.
On his own motion, or on any information received by him, or on the request of the Commissioner of Central or State Tax, as the case may be. So the clause 2, my lord, on any information received by him. In this, whether an application filed by the SSE or registered person would fall or not, that is issue. In this case, my lord, I filed revision application before the revisionary authority, and he returned it. He returned it saying that you go and file appeal. So the question arises whether the under the given facts and circumstances of the case, if the ingredient of limiting factors or the ingredient of 108 is satisfied, whether the 108 jurisdiction can be invoked by the SSE by filing an application or not, and whether such an application would constitute an information or not.
That's
If
right.
if that constitutes information, then the SSE can also invoke 108.
An information from the source of an SSE falls within the expression information or not under section 108.
My lord, my lord. My lord,
You
kindly
say
say,
that you say that it does so.
yes, it does so, my lord. Kindly see, my lord, A3.
Yes.
In the case of Lasser and Tubro, was state to Jharkhand, so and so, it is held by the Honorable Apex Court that the word information, the word in italics, my lord, is quoted verbatim from the judgment. These words are taken from the judgment itself.
Acha, Larsen and Tubro.
Yes, my lord. Its italics means taken as it is from judgment, my lord. The word information used in the aforesaid section is of the widest amplitude and should not be construed narrowly. It comprehends not only variety of factors including information from external sources of any kind, but also discovery of new fact or information available in the record of assessment not previously noticed or investigated. So whether information may be from any external source, not only from the record itself, but if some information is brought to the notice of the revisionary authority,
Yes.
my lordship would like to see the judgment of Lassen 2.
Yes, yes.
Our judgment is in volume. It is volume 2, my lord. It is in volume 2, my lord. It starts on page 53.
Volume 2. Yes.
Volume 2, my lord. It is on page 53.
Page 53.
And my lord, the relevant portions are on page 62, my lord. Para 26 at the bottom, my lord. Page 62, para 26, my lord.
Six. Yes, yes.
Page 62, para 26 at the bottom, my lord. It is also pertinent to understand the meaning of the word information in its true sense. According to Oxford Dictionary, information means facts told, heard, or discovered about somebody something. The law lexicon describes the term information as the act or process of informing, communication, or reception of knowledge. The expression information means instruction or knowledge derived from an external source concerning facts or parties or as to law relating to and or having a bearing on the assessment. Having a bearing on the assessment, we agree that mere change of opinion or having second thought about it by the competent authority on the same set of facts and material on the record does not constitute information for the purposes of the State Act. But the word information used in the aforesaid section is of the widest amplitude and should not be construed narrowly. It comprehends not only variety of factors, including information from external sources of any kind, but also discovery of new facts or information available in the record of the assessment not previously noticed or investigated. Suppose a mistake in the original order of assessment is not discovered by the assessing officer on further scrutiny if it came to the notice of another assessor or even by subordinate or superior officer, it would be considered as information disclosed to the incumbent officer. If the mistake itself is not extraneous to the record and the informant gathered the information from the record, the immediate source of information to the officer in such circumstances is, in one sense, extraneous to the record. It will be information in his possession within the meaning of Section 19 of the State Act. In such cases of obvious mistake apparent on the face of record of assessment, that record itself can be source of information. If that information leads to discovery or belief that there has been an escape of the assessment or under assessment or wrong assessment. Then, my lord, kindly come to page 65.
So here again, the opinion of the Honorable Supreme Court does not specifically mention of information from an assessor.
Yes, I am coming to that, my lord. All the judgments are there, directly on the point. Just I am coming to that. Those judgments are there, my lord. Just I am checking to the meaning of information and what are the sources of information. Information may be from the record or it may come from outside also.
Yes.
Page 65, my lord.
Page 65.
Para 31, my lord.
Yes.
The contention whether finding the information from the very fact that were already available on record amounts to information for the purpose of Section 19 of the State Act, it would be sufficient to refer to judgment of this court in RNG Haridas and Company Private Limited versus SP Kasture, wherein it was held that the fact which was already there in record does not by its mere availability become an item of information till the time it has been brought to the notice of the assessing authority. But I'll pause for a while. My point is that an information supplied by me from external source or information already in the record brought to the knowledge of the revisional authority that it is so in your record constitutes an information. Hence, the audit objection were well within the parameters of being construed as information for the purpose of Section 19 of the State Act. The expression information means instruction or knowledge derived from external source concerning fact or parties or as to law relating to and or after bearing on the assessment. We are of the clear view that on the basis of information received and if the assessing officer is satisfied that reasonable ground exists to believe, then in that case the power of assessing authority extends to reopening of assessment if for any reason the whole or any part of the turnover or the business of dealer has escaped assessment or has been underassessed, and the assessment in such a case would be valid even if the material on the basis of which the earlier assessing authority assessed passed the order and the successor assessing authority proceeded were same. The question still is as to whether the present case, the assessing authority was satisfied or not. Then, my lord, rest we are not concerned, it's not relevant to us. Then kindly see my judgment of Supreme Court in the case of my lord, kindly see page 95, Board of Revenue.
95.
95, my lord, 95.
Right.
Board of Revenue, Madras versus Raj Brothers.
Yes.
My lord, we are concerned with page 95 and the provision is quoted in page 97. Provision is quoted in page 97, my lord, para 2. In these appeals. In these appeals, we are called upon to determine the true scope of Section 34. Section 34(1) confers on the Board of Revenue, suo motu power to call for and examine an order passed or proceedings recorded by the appropriate authorities under some of the provisions of the Act. Section 34(2) reads thus: the Board of Revenue shall not pass any order under Section 1 if the time for appeal against that order has not expired or the order has been made the subject of an appeal to the appellate tribunal or of a revision in the High Court or more than 4 years expired after the passing of the order. Then, my lord, the relevant portions are on page 98. Last para, my lord.
98.
Next page, my lord.
Yes.
At another contention was taken. At another contention was taken on behalf of the state. It was contended on behalf of the state that SSC had no right to invoke the jurisdiction of the board to exercise its revisional power. This contention too has to be rejected. The power is conferred on the board to remedy any injustice. It is open to an SSC or the revenue to bring to the notice of the board any error made by the subordinate authorities. It is up to the board to consider whether the case is a fit case for exercising its revisional jurisdiction. If the board had gone into the case and come to the conclusion that there was no justification for exercising its power jurisdiction under Section 834, then in the absence of any vitiating circumstances recognized by law, the High Court would not have interfered with the discretion of the board. But what has happened in this case is that the board had refused to exercise its jurisdiction under the erroneous view that, in view of the dismissal of the SS's appeal, it was not competent to entertain the petition. The decision of the board was vitiated by an error apparent in the face of record. Hence, the High Court was justified in interfering with that decision. Whether the case is fit one for exercising jurisdiction of the board is or not is entirely a matter of the board to consider and decide. Then, my lord, kindly see. Next, my lord, page 100.
Just a minute. What is the citation of this?
My lord, citation at page 95, my lord. Citation,
Yes.
my lord, it is 1973. Kindly see page 96, my lord. 1973, 31 STC,
31 STC.
STC 434. 1973, 31
Yes.
STC 434, my lord. Then, my lord, kindly see.
In this case also appeal पहले हुआ पहले appeal हुआ और second appeal को translate to provision. How an SSC will say that it is judicial to the revenue? Section 80 of Derivative Act is not here. Section 80 of Derivative Act SSC were used here for filing division.
Morning.
Get to commercial test.
Yes.
My lord, next judgment on page 100, my lord. State of Tamil Nadu versus Mahalakshmi Textiles Mills Limited.
Yes.
My lord, the relevant portions are on page 101, para 4 at the bottom, my lord. Last but one para. In our opinion, my lord. In our opinion,
Yes.
in our opinion, none
Yes.
of the contentions has any merit. Section 30, subsection 2 prescribes three conditions for the Deputy Commissioner to pass an order under subsection 1 of the said section. A. The time for appeal against the order had expired. B. The order had not been made the subject of an appeal to the appellate assistant commissioner or appellate tribunal or a revision in the High Court. And C. More than 4 years had not expired after the passing of the assessment order. The above section shows that time limit prescribed does not prevent the Deputy Commissioner from passing an order on an application filed before him under section 32 within the period mentioned in the subsection. Here, the revision petition in 32 was filed by the SSI within a period of 4 years and he passed an order on latter date. As the High Court has rightly pointed out, just because the Deputy Commissioner took time to pass the order of, on the application of the SSI, it cannot be said that the time limit of 4 years prescribed by the section had expired and he had no justification to pass the order. We agree with the reasoning of the High Court and reject the first contention. Now comes the second contention, my lord, which is relevant to us. As regards the second contention, the section itself contemplates a revision being filed when there was no appeal before the appellate authority. In fact, subsection 2A says that a revision could be filed only after the time for appeal against the order had expired. That means if the SSC had not filed an appeal, that means
Yes.
if the SSC had not filed an appeal within the time prescribed, therefore, he could invoke the jurisdiction of the Deputy Commissioner under section 32. That is what has been done in the present case by the SSC. The mere fact that he did not invoke the jurisdiction of the appellate authority will not prevent the SSC from invoking the jurisdiction under section 32 of the Deputy Commissioner.
So the intent basically is that an appellate authority is not in season of the matter,
Yes.
so that conflict of decisions or parallel proceedings continue before two authorities over the same subject dispute within the same time.
My lord,
That is the whole intent,
my lord,
and a time limit of 4 years so that no stale matters can also be brought for revision.
my lord,
That is. Yes.
well, two paras from written notes I am reading, only just your lordship because you fell from your lordship, and now it is relevant at this point to just highlight why the longer periods provided in the revision powers. Power under revision power under 108, the period is longer. Under appeal, it is shorter. 3 months and 3 years. The reasoning behind this has to be borne in mind. The purpose is that no wrong order should be kept alive. And that is why a longer period is given in revision under 108 and in appeal the period is shorter. This is one thing, my lord. And the second thing, my lord, the power under 107 and 108 is one and same. What the appellate authority can do, the revision authority can also do the same thing. It can enhance, modify, annul, cancel. So both of them do the same thing. It is not that the power subscribed, it is reduced power or power is somewhere subscribed. It is not so. The power of the appellate authority and power of revision authority is one and same. So, my lord, and the judgment of the High Court.
So you can advance one more line of reason submission. I don't know whether in your propositions that you have framed that is there or not. You see, in many of the acts, not many, but at least in the IT Act, two revisional powers are conferred.
My lord.
One is 263, the other is 264.
My lord.
The legislature thought it proper to make it more clear that 263 is to be exercised suo motu by the revisional authority, and the SSC also is not denied another revisional remedy under 264. Now, expressions used in section 108 are in fact a combination of so many expressions.
Very correct, my lord. Very correct.
Which the legislature perhaps seems to have borrowed from different parameteria statutes or taxing statutes.
My lord.
To include in one provision instead of making it two, in one provision making it from information, suo motu, etc. And what is the other word used? On his own motion or upon information or on request of commissioner.
My lord, in written notes, my lord, I have taken that point while analyzing section 108.
I don't section 80 usually SSC but use to किया था must be some reason
वहीं पे रिवीजन पावर में SSC यूज अलग से थोड़ी
section 80 में क्या ये तो क्या अपील नहीं करते तो रिवीजन कर रहा है तो अपील में हम लोग तो कोर्ट से भी देते हैं तो हर एक आदमी फिर करेगा अपील
तो दूसरा तो जो 1973 वाला जजमेंट है उसमें काफी उसका एक्सरसाइज और डिस्क्रिप्शन जो रेवेन्यू का कंसोलिडेटेड हो सकता है
रेवेन्यू वाला जो सेक्शन है उसको पैरामीटर
बोर्ड ऑफ रेवेन्यू का पुट किया सेक्शन 32
हाँ सेक्शन 32 वाला है Section 32 to post of three conditions. The time to clear.
Call for an examine. Maybe so much to pass.
So much to clear.
इसमें सो वाले मतलब उसको एंटरटेन करने का
तो है बट इंफॉर्मेशन फ्रॉम एप्लीकेशन फ्रॉम द एसएससी एक भी फैक्ट नहीं एप्लीकेशन एसएससी दिया और उसके बाद तो दो चीजें एसएससी इंटरेस्ट प्रेजुडिशियल टू द रेवेन्यू व्हाई द एसएससी विल फाइंड anything which will be interest prejudicial to the revenue SSC will see to his interest, not the interest of the tax. यहाँ क्या हो कि सारे लोग इनकम टैक्स अपील फाइल किए जो है करेक्ट करेंगे और एक मॉडल भारी पड़ेगा हम लोगों को
लेकिन कोई एसएससी को ये नॉलेज है कि ये एडजुडिकेटिंग अफसर जो है ये ऐसा ऑर्डर पास किया है जबकि सेम प्ली पे जो करेक्ट ऑर्डर है वो अब ऊपर तक
क्लियर था जजमेंट है यहाँ हम लोग एक जगह खोलने जा रहे हैं अपील नहीं फाइल करके यहाँ ये चीज सबसे बड़ा But the main thing is that now every SSC will what they will do. They will file it.
Yes.
My lord, my written notes.
Yes.
Kindly see my written notes, my lord, containing 8 pages.
Yes.
Page 3, my lord.
Yes.
Para B3.
Yes.
Or I would say para B2 also is relevant, my lord.
Yes.
Petitioner most humbly submits that in order to invoke Section 108 of the JGST Act 2017, the conditions the conditions of the decision or order of the erroneous subordinate officer being erroneous or prejudicial to the interest of revenue and is illegal or improper or has not taken into account certain material facts are satisfied, it would be incumbent upon the revision authority to exercise its divisional jurisdiction under Section 108 of the Act. The discretion under 108 has to be judicially and reasonably exercised. Then B3. The provision of Section 108 of the JGST Act 2017 is of wide import. It is wider than Section 263 of the Income Tax Act 1961. Section 108 of the JGST Act can be invoked by the revisional authority on his own motion or upon information received by him or on the request of Commissioner of Central Tax, State Tax, as the case may be. Under Section 263, the Principal Commissioner, Chief Commissioner of Income Tax may exercise revisionary powers only on his own motion.
Yes.
B4, my lord, the power under Section 1081 is at par with appellate power under Section 10711 of the JGST Act. Under Section 10711, as also under 1082, the authority can pass such order as it thinks just and proper, including enhancing, modifying, or annulling the decision or order. The power under Section 108 and 107 is almost similar. So, my lord, there are two alternative routes available. It is not that if somebody has not filed appeal, I will come to that also, my lord. If somebody has not filed appeal, does not mean he cannot invoke 108. There is no bar in invoking 108. Only thing is that he cannot have both the remedies. Even somebody has filed an appeal, but one of the point was not an appeal. On that particular point, the power under 108 can be exercised. Assuming, my lord, in a case, there are 4 points involved. On 3 points, appeal is filed. 4th point was not in appeal. On the 4th point, this power under 108 can be invoked by the revisional authority himself, suo motu, on an information or on the request of the Commissioner of.
Is the CGST party in any of the writ petitions?
Pardon, my lord?
Is the CGST party in any of the writ petitions?
No, Manoj. No.
So, since the interpretation of the Act is involved and it applies to state authorities as well as central authorities, why should we not impede the CGST to have their point of view and how they are exercising? Mr. Kurmi might be knowing about their outlook of the CGST authorities, whether this interpretation is being accepted by them. But for the court's benefit, we can ask the CGST to join and assist us on this interpretation. This actually, any judgment by us would apply to the central authorities also. So let us have the benefit of this CGST.
Yes, my lord. Yes, my lord.
Mr. P.S. Pati is appearing in some of the writ petitions for the state.
Yes, Manoj.
If he can join and ask Mr. Amit Kumar to appear for CGST, You can
just
increase
call him up.
this. You can call him.
He will call either of the two persons.
My lord, may I proceed?
We are stuck at that stage. So, if CGST is also being added as a party, then you may reserve your argument for. We have understood your
Understood
submission,
your argument,
and it actually you are asking the court to take a wider interpretation of the provision for two reasons, basically, that there is no other provision of revision under GST Act, and the second one being that all expressions suo motu on his own motion from the on information or from the commissioner's source, all these expressions are included, and the grounds are also quite wide. The grounds are not only erroneous, prejudicial to the interest of revenue, but illegal, improper, and one more ground is there.
Matter not taken into consideration.
Matter not taken into consideration. So, you want a wider interpretation to be taken so that the SSC also has an option or a remedy in revision apart from appeal.
Right, my lord.
He is conscious, the SSC may be conscious that till the expiry of the appeal period, he cannot seek revision. There is also a risk that if he doesn't go in appeal and waits for the time limit to be over, garnishee proceedings could be initiated and the recovery could be made through different methods under the Act, Section 79 and all. But still, the SSC can choose to not invoke the appellate remedy and wait for the revisional remedy to be invoked.
My lord.
And since the time limit for revisional remedy is larger, it can also happen that initially the SSC may not have understood the lacunae in the order. Later on, he realizes that yes, this is something which is not only erroneous, but it is prejudicial to the interest of revenue or illegal or improper or other materials. So, the stage for its rectification has not expired. It can be still corrected in a revisional exercise of power. So, basically, you are asking us to take a broader view of the provision rather than to restrict its interpretation, ousting the SSC source completely out of it.
My lord. My lord, when one of judgment,
264 are intermingled in this section, 108. In Income Tax Act, 264 is a separate act.
correct, my lord.
Provision. But here, 264 and 263 are
It's a merger of both.
merger of both.
Merger of both. And sorry, my lord.
That,
Sorry, my lord.
so, since the provision are same in CGST and SGST, so it is better to take their.
My lord, definitely, my lord. Definitely, my lord. My lord,
What was the bill and the recommendation before the Parliament while enacting the GST Act?
my lord, I will place before the lordship. I will place my lord before his lordship.
Any discussion on why this
Yes, my lord.
exact language has been
Yes,
used
yes.
in
Yes, yes.
108?
The entire journey I will take you before lordship. My lord, what I am trying to just, I will not take much time in lordship because the lordship wants to hear the other side also and the CGST. But I am just disclosing my mind, my lord, what I have understood about it. My lord, 108, if we can see from a different angle, 107 vis-a-vis 108. Simply because under 107 there is a 10%, so 108 will become redundant. It is not so. There is a presumption against redundancy. The legislature very well knowing that there is 107 being inserted with a precondition of pre-deposit, still thereafter 108 is invoked, enacted, meaning thereby that if appeal is not filed, then the remedy under 108 can be availed. and the period of 108 is larger than period of 107, also meaning thereby that those who have missed appeal and still the order, if it satisfies the condition of 108, you can have the remedy under 108.
Actually, what you mean to say, of course, expressed in a different language, can also be said that 108 being in the nature of a supervisory jurisdiction
My lord.
doesn't need to be looked at from the prism of a SSE only. Anywhere where there is a supervisory jurisdiction, that jurisdiction is basically to correct the errors of the inferior court. And if the errors are pointed out from any source, why should it be overlooked?
Correct, my lord.
In case the conditions prescribed under that provision are met, erroneous, etc. So we have been looking at it from the point of view of a failed SSE who has not invoked Section 107 and now wants to take the benefit of Section 108. But if we look at from a larger perspective, that 108 is basically to correct any kind of error within a time limit and from different sources. Why should that revisional power be restricted? The power may not be exercised in a particular case is a different situation. But to curtail the power per se as a whole on the assumption of floodgate theory, generally about PIL and all, that is not the correct thing.
My lord, yes, that is correct, my lord.
When we are asked to answer a constitutional issue or a legal issue, we should not. In fact, I was going through the judgment of Justice S.B. Sinha in that G Telefilms case in which His Lordship took a different view of BCCI. By dissenting judgment, of course. This was the view expressed that the floodgate theory should not restrict any constitutional court from deciding the legal question in favor, simply because so many petitions would be filed before the revision.
May I submit, my lord, something?
Yes, yes.
It is a very interesting issue, my lord. I have also examined. My learned friend was submitting, my lord, that the scope of 108 and, my lord, the scope of Section 107. The lordship will be perhaps, my lord, required to, my lord, decide one issue, that when a statute, my lord, provides two remedy, one of appeal, another of, my lord, revision, whether both can operate, my lord, in the same field, within the same sphere, within the same scope, my lord, or when legislature has provided two different remedy, then they will operate in different, my lord, sphere, my lord. Because, my lord, 107, if you also will see the language of 107, and even otherwise, my lord, the general principle of law is, my lord, that appeal is continuation of, my lord, the original proceeding. That principle will apply everywhere. This principle will not apply, my lord, so far divisional jurisdiction is concerned. If your lordship see the language of Section 107, it says, my lord, that the person aggrieved by any decision or order, may prefer an appeal. So, my lord, the ground under Section 107 for filing an appeal is much wider, my lord, than the, my lord, the grounds under Section 108. My lord, for exercise of power under Section 108, two, my lord, conditions are required to be fulfilled. Number one, erroneous, coupled with the fact, my lord, that it is prejudicial to the interest of the revenue also. Only because an order is erroneous or it is prejudicial, my lord, Section 108 will not apply. To my lord, invoke the jurisdiction under Section 108, both the conditions have to be applied simultaneously. And, my lord, so far the word erroneous is concerned, several judgments, my lord, the Honorable Supreme Court has considered, and other high courts, my lord, have considered. What is the meaning, my lord, of the word erroneous? Erroneous, my lord, your lordship will find that there are judgments, my lord, that, my lord, patent illegality, my lord, in passing the order. That may be a ground, my lord, to invoke, my lord, this Section 108. Other, my lord, some of the judgments, my lord, which I have examined, which says, my lord, that And Milord, so far section 108 is concerned, it has to be Milord, the grounds have to be taken from the records only. Milord, that is one of the limitations under section 108. Moreover, Milord, there is a distinction between lack of inquiry and Milord, inadequate inquiry. If Milord, there is inquiry Milord, the conditions are fulfilled. Section 100 cannot be. Even if there is Milord, the inquiry is inadequate, still Milord, section 108 cannot be invoked. So, Milord, the parameters to invoke section 108 can't be Milord similar to section 107. Kindly see Milord, the language of section 108.
Very elementary understanding of all revisional powers, and which applies to all revisional powers starting from the High Court 227, CPC section 115, or any other statute. Basically, revisional power is a supervisory jurisdiction.
Supervisory, yes, Milord.
Purpose is to keep the inferior authority within the bounds of its jurisdiction.
My Lord.
Three conditions are generally prescribed, that is illegality, irregularity, or impropriety.
Yes.
All three conditions are generally found in all these revisional powers. Now, what you are saying that they have to be looked in from the records of the case, the SSC cannot take any grounds. In appellate court, the court has a much wider power, but in revisional jurisdiction, the revisional authority would not substitute the discretion of the original authority by its own finding, if that is an also alternative view of the matter.
Two views are possible, Lord. One view has been accepted by the AO, then the revisional authority will not substitute its own view.
Yes,
that is the law.
Those broader outlines and guidelines are there for exercise of revisional power. The SSC invoking section 108, I am arguing for the petitioner for the time.
My Lord.
The SSC invoking section 108 is operating under a conscious weight that the scope here is very limited. Scope is very limited. He has lost the remedy of appeal or he has not invoked the remedy of appeal. If only the given parameters of illegality, irregularity, impropriety, coupled with prejudicial to the interest of revenue, is brought to the notice of the revisional authority, then the power will be exercised. But it is not that there cannot be even one instance where that can happen. Even if there is one instance where that power can be exercised,
then it's okay.
Then it's okay. We need not curtail that power for all purposes altogether.
Only to stop the floodgate, we cannot decide.
Milord, that is one aspect. Your Lordship can declare the law or Milord clarify the issue. So far, the facts of this case is concerned, whether that benefit will be given to the petitioner or not, that is a different issue. These are two distinctive Milord issues. Section 100, if your Lordship may kindly see, Milord, the word erroneous, Milord, to the and prejudicial to the interest of the revenue. Milord, there is and the word is and is illegal or improper also. And is illegal or improper also. So if all these conditions are satisfied, then only Milord
that will be decided subject some order will be passed. So
yes.
At present we are seeing whether
you see, there are
the SSC can file appeal a revision without appeal or not.
You see, in any such litigation, there are two parts. One is the jurisdictional part and the other is the adjudicatory part.
Yes.
So, jurisdictional part comes whether the revisional authority can entertain an information from the SSC source. Whether in the adjudication part, the ingredients are fulfilled or not, that's a separate chapter.
Yes.
We do not want to get into that. Neither the court is sitting over that part of it.
Yes, yes, right.
Whether this SSC's case fell into any of those categories and the jurisdiction has been wrongly decided, that we are not looking into it.
Yes, yes, my lord. I understood, my lord.
So basically, these are two very clear compartments.
Distinction, my lord. Yes.
The necessary jurisdictional fact to assume jurisdiction, and once you assume jurisdiction, you decide wrongly, rightly. Those are adjudicatory part.
then the issue, my lord, then the issue that when two remedies have been provided in the statute, then what will the scope and ambit of both the provisions that your lordship will be required to consider? That your lordship will be required to consider. Perhaps you might submission, my lord, that.
My lord, under 107, an appeal may be filed by the SSC and also by the department. So what would apply to the SSC would equally apply to the department also. If department misses an appeal, so my lord, that is why 107 and 108 requires to be interpreted in such a way that it affects none of them adversely. Under 107(1), an SSC may file appeal. Under 107(2), 3, 4, the department can file an appeal. Then, my lord, suppose department missed the appeal as the SSC. SSC missed the appeal. My friend is saying that the SSC missed the appeal, then the 108 cannot be invoked. Then the department also stand on the same footing when it comes to 107(2). Kindly see, my lord, 107. I'm just reading, my lord, 107.
Yes.
With the permission of the commissioner, that is department number 5.
अपील हम दोनों लोग कर सकते हैं तो रीजन वही तय करेगा ये फंड है
Yes.
107 when the party misses an appeal, 107(2) when the department misses an appeal, then both of them will have the remedy of 108 or not. I am submitting on that, my lord.
Yes.
107 appeals to appeal authority.
Yes.
Subsection 1, any person aggrieved by any decision or order passed under this act or the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act by an adjudicating authority may appeal to such appellate authority as may prescribed within 3 months from the date on which said decision or order is communicated to such person. 2. The commissioner may, on his own motion or upon request from the Commissioner of State Tax or Commissioner of Union Territory Tax, call for and examine the records of any proceeding in which an adjudicating authority has passed a decision or order under this Act or the State and Goods and Service Tax Act or the Union Territory Goods and Service Tax Act for the purposes of satisfying himself as to the legality and propriety of the said decision or order, and may, by order, direct any officer subordinate to him to apply to the appellate authority within 6 months from the date of communication of the said decision or order for the determination of such points arising out of the said decision or order as may be specified by the commissioner in his order. 3. Where, in pursuance of an order under subsection 2, the authorized officer makes an application to the appellate authority, an application shall be dealt with by the appellate authority as if it were an appeal made against the decision or order of the adjudicating authority, and such authorized officer were an appellant, and the provisions of this act relating to appeals shall apply to such application. 4. The appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allow it to be presented within a further period of 1 month. Why? Every appeal under the section shall be in such form and
Actually, just to further what you were saying, under section 108 2B, after the expiry of within the expiry of 3 years of the passing of the decision or order sought to be revised, the person is entitled to invoke revisional remedy.
my lord.
So, a person exercising appellate power, exercising appellate jurisdiction is also not in this section 108. If a person prefers an appeal and that appeal has been decided, whether that person can invoke revisional jurisdiction or not.
In my understanding, yes, my lord. I will come to that also.
of GGST. Forward use clear. They can find it. Your revision commercial tax में जो बना है.
अच्छा.
तो वहाँ सेक्शन 80 के तहत आता है, तो वहाँ यहाँ वर्ड यूज नहीं, दो पॉइंटेड क्लोज, एक तो आपके बोले हम कैच कर लेंगे, in only in order to stop the flood rate we cannot listen more, I understood. And secondly, suppose by ignorance of law, though it is not an excuse, but if I miss the bus, whether I could see all this, at least it's a factor aspect. हम लोग पे बर्डन तो जाना पड़ेगा, फैक्चुअल चल पड़ेगा, जो उसको हम लोग सीरियसली बना करके इसको स्टेट कर देते हैं। Mr. Amit Kumar is.
Mr. Amit, have you joined?
Yes, Lordship.
So, we are seeking your assistance on the interpretation of section 107 versus section 108.
Yes.
Vis-a-vis section 108.
Yes.
In any one of the writ petitions, if you are included, that will serve.
28 का ही सर ये लीड केस है।
Well, it's in serial number 20, WPT 28 of 2021 will serve the entire set to him.
Yes,
That is what we are saying.
that will serve our purpose, everybody's purpose.
So, my lord,
Yes.
my point is that an appeal order 1077 lies before the appellate authority at the behest of the HSC or the department. In case of HSC, it is 3 months plus 1 month. After that, it is barred by limitation. On behalf of the department, it is filed 6 months plus 1 month. Then barred by limitation. My submission is that even those appeals which are barred by limitation, even against those appeals, revision may be filed. Point number 2, my lord, grounds taken appeal and grounds not taken appeal. The grounds which are not taken appeal, against that a revision will lie. Point number 3, my lord, the appellate authority has passed order. The appellate authority is subordinate authority. The appellate authority is subordinate authority. In the writ petition, my lord, the notification of the under the JGST Act is enclosed at the last page, and it designates this division authority of different hierarchy, my lord. Page 113, the writ petition says, I am reading, my lord, please don't take the pen. Notification number 5 by 2020, dated 19 June 2020, in pursuance of the provisions of section 5, rate which clause 99 of section 2 and section 108 of the Jharkhand Goods Service Tax Act 2017, the state government here authorizes the commissioner of state tax for decision of order passed by the additional or joint commissioner of state tax. Commissioner against order of additional joint commissioner and additional or joint commissioner tax for decision or order passed by the deputy commissioner of state tax, assistant commissioner of state tax, or state tax officer. My point is that, my lord, the appellate authority is a deputy commissioner or the additional commissioner, and he dismisses the appeal. Then whether a revision will lie before the commissioner or not. Because the purpose of revision is to keep the subordinate authority within the bounds of their authority and jurisdiction. Now, an appellate authority who is subordinate to the commissioner, he passes the appellate order this way or that way, which is not within his jurisdiction, whether the commissioner can exercise 108 power or not.
Right.
My answer is yes, it can be. Not only against assessing authority orders, but also against the order of the appellate authority, if he is subordinate authority.
Very well. Since arguments have been advanced in the lead matter, in WPT number 28 of 2021, which is the lead matter, in the present batch of writ petitions by Mr. Karthik Kurmi, assisted by Mr. N.K. Prasadi and Mr. Siddhi Jalal. Stop. In all these writ petitions, the main legal issue is regarding the interpretation of Section 108 of the GST Act. Stop. In all these writ petitions, a revision preferred by the SSE invoking Section 108 of the JGST Act has been declined by the revisional authority only on account of presence of an alternative remedy of appeal under Section 107 of the Act. Mr. Pasari, whether in all of them they have been declined or in some of them they have straight away come.
Minutes, only to clarify, Minutes, it is not the revisional authority who has declined. A subordinate to a revisional authority has returned that prefer an appeal.
तब फिर इसको ऐसे लिखिए. In all these writ petitions, the revision application preferred by these petitioners under Section 108 of the JGST Act has been returned
Yes, Minutes.
by the concerned authority on
With a direction to file an appeal, Minutes.
with a direction to prefer an appeal under Section 107 of the
Yes, Minutes.
Stop. Whether no revision would lie at the instance of whether any revision could lie at the instance of an SSE under Section 108 of the GST Act or not is the legal issue to be answered in this batch of writ petitions. Stop. Though the present batch of writ petitions arise out of the provisions of the JGST Act, but since the provision of Section 108 is same and identical in both the JGST Act and the CGST Act, or even the IGST, no?
No, IGST is no separate provision there, my lord. It
Union
only
Territory.
borrows from the CGST.
On the CGST Act, we deem it proper to have the stand of the central authorities on the interpretation of Section 108 of the Act, GST Act. Stop. As such, counsel for the petitioner is directed to implead you give the name, etc., Mr. Amit?
Yes, Lord.
Principal Commission. Send it on WhatsApp so that.
Yes, Lord.
Through so and so, as respondent number 5 in the writ petition number, tax number 28 of 2021. Stop. Let it be done. Let such addition be done by Friday by learned counsel for the petitioner. Stop. Copy of the entire pleadings be served upon. Let copy of the entire pleadings be served upon learned counsel for the CGST, Mr. Amit Kumar. Stop. Mr. Amit Kumar accepts notice on behalf of the newly added respondent. Stop. He speaks and is allowed how much time? 3 weeks?
Yes, sir.
He is allowed 3 weeks time to file counter affidavit on the question of law involved
Lord.
or on the legal issue involved in these cases. A legal issue involved herein. Stop. Today is 23rd. You can keep on the 25th. 25th April.
My lord, Tuesday, my lord.
No, Monday.
5th April, my lord, it is Tuesday, my lord.
No, 25th April is Monday, 26th is Tuesday.
Or 25th, my lord. My lord, let it be 27th, my lord. Maybe,
Maybe till that time.
my lord, maybe if all the days are virtual, then it will be fine for me. Otherwise, my lord, there is some 27th, my lord.
Your physical presence creates more impact.
My lord, in fact, the communication from here is very poor. My lord, I start in the morning. By 7, I take my train, my lord. I reach there by 10:30, 10:45. That is the difficulty only. And evening
That's
trains,
what
my
I
lord,
propose.
all the days it is not there.
But it's why what I propose, let it be Monday only. We will force the senior to come down with us to have a better impact.
Sorry.
25th, my
Yes,
lord.
yes.
Yes, yes. 25th April 2022. Stops. Petitioner and counsel for the petitioner may file reply to the affidavit well before, to the counter affidavit of the CGST at least 3 days before the next date. Stop. Let the name of Mr. Amit Kumar be reflected in the cause list for the respondent CGST in WPT number 28 of 2021 henceforth. Yes, sir, arrange.
Lordship, may I mention serial number 28?
Wait, we are
Writ
going to call your case. Wait. ये सारा एक साथ लगेगा, उसको थोड़ा पिन कर दीजिएगा, नहीं तो ये सारे पिटीशन का 2 पेज का समरी है.
Item number 28, WPG number 5531 of 2021, Mr. Anish Kumar Mishra for the petitioner. Mr. Manish Kumar for the rest.
Lordship, this writ petition has been filed challenging the jurisdiction of Jharkhand state to levy VAT on those goods which were supplied from the state of Karnataka on payment of CST. And Lordship, even for the earlier period, we filed the writ petitions. Those have been admitted, and there is a complete stay on the recovery. And this is a periodical matter, and for this financial year also, the similar writ petition has been filed.
You are appearing from any outstation?
Lordship, Mumbai.
We can take it up on any other day. Time is over.
Lordship, maybe next to date, whenever Lordship is sitting on virtual mode, that I will request.
So it will simply be passed over for the day. Next Wednesday it will be there.
Next Wednesday.
One more writ petition is pending, my lord. So let it be, my lord, along with that matter.
So that is an admitted matter or under admission?
That's an admitted matter. It is at pre-admission stage, Lordship.
Side by side.
Lordship, if my learned friend is ready, then we can even take it up for final disposal, because Lordship, this issue is precisely covered in so many decisions of Honorable Supreme Court, this High Court, and also in my own case by another High Court.
What is the other writ petition number?
The Lordship, the other writ petition number is
3647 of 2016.
3647 of 2016 and 3668 of 2016.
Both are admitted.
Both are admitted, Lordship.
3647 of 2016.
Lordship.
And
3668 of 2016.
2016. Learned counsel for the petitioner submits that the issue in the present writ petition is identical to WPT number 3647 of 2016 and 3666 of 2016 concerning the same petitioner.
Same issue, Lordship.
Stop. Involved and concerning the same petitioner. Stop. In the both these writ petitions, both those writ petitions, both these writ petitions, the petitioner has been granted interim protection.
Complete, Lordship.
Stop. As such, let the records of WPT 3647 of 2006, those petitions have been admitted for hearing. So, as such, let those writ petitions be placed, the records of both the writ petitions be placed along with the instant writ petition on the next date. The matter should appear on next Wednesday.
Lordship, just request for the interim protection.
No, on the next day.
No.
Add interim relief, Lordship, in between. No precipitory actions.
No, next Wednesday, whatever. We have not even applied our mind to it.
Lordship, immensely obliged.